To the appellate court, I'm Judge Bright. I'm sitting this morning with Judge Albert and Judge Pellegrino on the matter of State of Connecticut versus Charles Marshall. Docket number is AC 43866. This argument is being conducted over the Teams platform, so everyone is appearing via video conference. In addition, the argument is being streamed live over the branch's YouTube channel. So I would remind everyone that to the extent there's any protected information involved in this case, that you make sure to be careful not to disclose that protected information. I'm going to ask everybody to introduce themselves so that we can make sure we can all hear each other and see each other okay. I'll start with the judges, then the appellant, then counsel for the appellee. And I'm Judge Bright.
Good morning, I'm Judge Albert.
I'm Judge Pellegrino. You can hear me?
Yes.
Okay.
Mr. Marshall, can you just introduce yourself?
Yes, my name is Charles Marshall, self-represented for the petitioner, the appellate. Charles Marshall.
Assistant State's Attorney Sarah Hanna on behalf of the state.
Okay, I can hear and see everyone okay. I assume that's true for everyone else. If at any time you're unable to hear anyone, please let us know. If you're unable to see anyone, please let us know. If you get disconnected from the argument for whatever reason, please go back to the link and click back on. We will suspend the argument until we make sure we have everyone present. I'm going to ask everyone, to the extent they can, to keep their microphones muted when they are not talking to avoid any background noises. The judges are going to do the same. We will raise our hands if we have questions, and we would ask the parties to recognize us. If you don't recognize us for whatever reason, we may just jump in like we would if we were in the courtroom. I would ask everyone, though, to keep their camera on at all times so we can make sure everyone is still present and appropriately engaged in the argument. And I'll remind everyone that although we're not in the courtroom, this is a court proceeding and we expect everyone to conduct themselves accordingly. Each side will have 20 minutes to argue. I will keep the time. We do not have our light system, so I will hold up signs to let you know when you have 2 minutes left, 1 minute left, and time is up. The appellant can reserve some of its 20 minutes for rebuttal. Mr. Marshall, are you ready to proceed?
Yes, I am, sir.
And how much time would you like to reserve for
May I
rebuttal?
have 5 minutes of my time reserved, please?
Absolutely. You
Thank
may
you.
proceed.
Oh, thank you. This is a case where the primary issue concerns a statutory construction and the repeal of a statute or a portion thereof of section 53A-40 of the Connecticut General Statutes about the state legislators deemed unconstitutional. It was a special session in January 2008 in which that a certain portion of the enhancement statute was deemed unconstitutional, where it allowed the judge to make enhance a person's sentence on his opinion that that person is worthy of it or deemed worthy of it. Also, the dictates of practice book 43A29 concerning probation and the state's failure to adhere to those dictates. Your Honor, I would first like to get a few things. I would like to correct on a record that was presented by the state in this brief to this court that was incorrect. And the state's appendix A94 and A96, which is a minor error, but my middle name is incorrect. But seeing that we are dealing with facts and that the state has requested numerous continuances, I had a couple of peer reviews that the attention to detail to make sure at least my name is correct should have been somewhat important. For they put Charles F. Marshall and my middle name is Charles Edward Marshall. The second issue was that the state consistently cited that I was charged with being a dangerous felony offender. That's incorrect. I was charged with 53A-40 of the Connecticut General Statutes, which is a persistent serious felony offender. They have me as a dangerous felony offender on 3 counts. Also, third, the state cited in this brief, an appendix to this court, that I was charged with 2 separate armed burglaries. That is incorrect. Armed in the Black Law Dictionary, 10th edition is a person equipped with a weapon, armed robbery or robbery. And armed under the Merriam-Webster Dictionary and the Thesaurus 2019 defined armed as a firearm. The fourth issue is the state also claimed that I was tried on 2 violations of probation Also that at the time of my offense, I was being supervised on 2 probations. That is also not true. I was never on probation. I've never signed a contract with a probation officer. I've never met a probation officer. So I was not being supervised and I was never on probation. The prosecutor argued the probation during my trial. And I never had a revocation hearing, which is one of the issues I have before this court now. And after receiving a copy of the trial exhibit list and reviewing the list, I see that the probation contract, which has on it which conditions not to violate, and the signature, this contract is not present. Either it was omitted or it was not produced because of its non-existence. And the 5th issue is, excuse me, on the Part B list of the exhibits, separate from the trial list exhibit, I see that no exhibit for the priors used as qualifiers was for the enhancement is present. The 6th issue is the state misrepresented the facts on a certification signed by the state's attorney, Patrick Griffin, that I was put to plea on 9/13/07, which is another issue I have before this court, which is the notice issue or the enhancement. On November 13, 2009 and November 16, 2009, the day of trial, the notice of the Part B was given. The state certified that I was put on notice before being put to plea. That was incorrect. And the 7th issue is the state claimed that, quote, the defendant stipulated to the facts that he was on probation to both counts, unquote. The exhibit list provided by the state is void of such a stipulation. So those were not on the exhibit list because they was all incorrect. Also, the state in her appendix in part 1 and 2 to this court on A155-1A underlines with the intent to emphasize home invasion, burglary in the 1st degree with a firearm, and burglary in the 2nd degree with a firearm. And I was never charged with any of those crimes. So all the crimes that they have that I've had are dangerous, felony offender, firearm, and burglary with a firearm. All of those are not me. So I don't know if there's another Charles F. Marshall, if they got confused with me, but those are not my issues. That's in the appendixes and the charges from the state. I was never charged with none of those crimes. Y'all hear me? Okay. Thank you.
Yeah, we're just all muted, so yes, you're good.
Okay, so thanks for indulging me. All right, thank you. I have one final issue. I filed several motions for articulation denied by the Fasano court, and it was dismissed by this court as premature pursuant to Bricky versus Bricky. I refiled at the appropriate time sometime thereafter, and this court sent Fasano the motion for articulation, and this court notified me by mail that the motion for articulation has been sent to the Fasano court, and I have since heard nothing from this court or the Fasano court of the motion for articulation. Because when he did the memorandum of decision, I was unable to make argument from his decisions, which were vague and very short. And this court always say that in order for us to make our argument, we have to have adequate record. And I don't know if anybody received our articulation. Was it done by Fasano, or do this court already have it? So do I keep going? I just keep going? Okay. All right. Your Honor.
You have 8.5 minutes of your 15 minutes left.
Okay. The state seems to be saying that the statute that was deemed unconstitutional by the United States Supreme Court in Apprendi versus Jersey is relevant. The court must be of the opinion that extended incarceration best served the public interest was saved by section 54-194 of the Connecticut General Statute, which states in part that the repeal of any statute defining or prescribing the punishment for any crime should not affect any pending prosecution. Well, just for the record, the language in that, Your Honor, is clear. And this statute, when it mentions two relevant words, which are crime and prosecution, my argument would be that the prosecution has already been commenced. The enhancement is the second part of the prosecution, dealing with sentencing above and beyond that which the original statutory maximum will allow, thus require the separate trial. in Apprendi, it says it is unconstitutional for a legislator to remove from the jury the assessment of facts that increases the prescribed range of penalty to which a criminal defendant is exposed. The Connecticut statutory scheme allows a jury, in my case, a judge, to convict me, the petitioner, based on this finding beyond a reasonable doubt that I unlawfully committed a burglary first, assault first, and a Class B felony. And after a subsequent and separate proceeding, it then allowed the judge to impose punishment identical to that Connecticut provides for crimes of the Class A felony, pursuant to 53A-38 of 35A, subsection 4 and 5, based upon the judge's finding by preponderance of the evidence that I would, based on the judge's opinion, reoffend based on my criminal history, the seriousness of the offenses now convicted of, the need for deterring me from violating the law in the future, ruling burglaries to be a violent crime because of my drug use and false testimony, all in violation of Apprendi. In Apprendi, Westlaw, the degree of culpability the legislators associates with factually distinct conduct has significant implications because both for the defendant's liberty and for the heightened stigma associated with the offense, the legislators have selected as worthy of the greater punishment. Now that the state placed the enhancer, because the state placed the enhancer within the criminal code sentencing provision, does not mean that it is not an essential element of the crime of the offense. In Jones versus United States, it was cited that under due process clause of the Fifth Amendment and the notice and jury trial guarantees of the Sixth Amendment, any fact other than a prior conviction that increases the maximum penalty for a crime must be charged in an indictment and submitted to a jury and proven beyond a reasonable doubt. The 14th Amendment commands the same answer in this case involving the state statute. Your Honors, just because it took the state years to catch up to a statute that was unconstitutional on the day of its inception, the saving statute 54-194 does not cure the unconstitutional of its power, the unconstitutionality of its power. You cannot cure that which was terminal the day it was enacted. So the public interest portion of it was deemed unconstitutional by the U.S. Supreme Court. And the court, the state seems to think just because a statute was enacted by the legislators that supersedes the unconstitutionality of the enhancement that was repealed by the state Supreme Court in 2008. Now, the notice requirement came from, I was put on notice in 2009 of this statute. And in 2009, when that statute, in 2009, when I was put on notice, I didn't know that the state was going to charge me with an enhancement. If I'd known that the state was going to charge me with an enhancement back in 2007, that could have gave me a better chance of whether to take a plea or not. If I knew that I could be enhanced with a charge that can give me a life sentence, basically a life sentence under Connecticut law or statutes, then that could have better prepared me to take a plea. But because I was put on notice in 2009 of this statute, I'm saying that was deemed unconstitutional in 2008, I didn't have time to prepare for it. So therefore, it was in violation of my right to have notice to be able to prepare for this, the enhancement. And how much time am I short?
You have about 3 minutes and 40 seconds left. I had a question for you, Mr. Marshall. I just want to ask you about what you were just saying about notice.
Right.
Did you have notice prior to your trial that the state had charged you with being a persistent offender?
Yes, the day of my trial was the 16th. They notified me on the 16th, and I think it was 2 days and a day of trial. So it was 2 days before trial, I think, and the day of trial, I was notified of it.
Okay.
And they had, that's not enough time for me to have notice to prepare. So my attorney explained to me that, if you just take the deal, the judge might be lenient as opposed to going to trial. Now, at the time, I didn't know what an enhancement was. So when he explained to me that if you take the deal, I end up getting a life sentence for taking a plea deal That's not a plea deal. A plea deal is a give and take. So for me to plead out to a life sentence is just wrong. You know, my lawyer allowed me at that time when he explained to me what an enhancement was during trial, and just to take the plea, then I took the plea on the advice of counsel. But the notice wasn't given to me in adequate time for me to prepare, you know, for the enhancement. If I'd known this prior to, or back in 2007, or prior to the change of law in 2008, then that could have better prepared me to even take a plea, as opposed to end up with 60 years, 62 and a half years. So, and I have here too, one more thing, the issue with the probation. First, the city of Bridgeport, the Superior Court did not have permission to transfer my probation to Waterbury, which is a jurisdictional issue. The Superior Court on May 1st, 2008, Attorney Castanado, before Judge Fichetti, said that I waived appearance and transferred the probation files. That is not true. I never waived appearance. I never knew a hearing was occurring, which not only became a jurisdictional issue, but also a critical stage issue. The state presentation of the violation of probation hearing within my criminal trial did not satisfy the requirements of 42-2 of the practice book. No procedural safeguards were provided by the state, the court, or my attorney, Dennis Harrigan, which cast a shadow on the fairness and integrity of the judicial proceedings or the just character of the trial's outcome. I received no benefit of a hearing. I can't find in the trial's exhibit provided by the state for this hearing a certified record of probation and or conditions not to violate, nor was I identified by a probation officer as required by the revocations or procedures. So I think that's about it. It's not enough for a minute, but I tried to get as much in as I could.
All right, you still have 5 minutes left for rebuttal.
Okay. I just, and I would just ask the court to just defer to my brief, because basically I have most of my arguments in my brief.
Yep.
Which I think I got most of my answers that I need for y'all to know in my brief. Yep. So I appreciate that.
Okay. All right, you all have 5 minutes for your rebuttal after Attorney Hanna. Are you ready to proceed, Attorney Hanna?
Yes, Your Honor. Good morning. May it please the court. On behalf of the state senior assistant state's attorney from the appellate bureau of the office of the chief state's attorney. On appeal, the defendant challenges the trial court's ruling in 4 respects. As fully set forth in the state's brief, all of these claims fail. First, under the authority of Bell and Apprendi, the defendant contends that he was required to explicitly waive and admit the public interest issue. This is incorrect. The defendant expressly waived his jury trial on the Part B information and agreed to the court making the requisite finding, which it did. The trial court's actions satisfied the requirements of Bell, and there was no error. Second, the defendant argues that the legislature's amendment to the persistent offender statutes invalidated the trial court's actions under the prior statute. There's no legal basis for this argument. The trial court applied the statute in existence at the time of the defendant's crimes in accordance with the terms of the statute and the law set forth in Bell. The defendant also contends that he's entitled to a probable cause hearing because the aggregation of his exposure for all of his offenses was greater than 60 years. This claim relates to trial error rather than sentencing, and the trial court did not have jurisdiction over it. Therefore, it should have dismissed rather than denied that claim. As to the merits, as this court held in Edwards, the probable cause statute is directed at singular offenses carrying a potential term of life imprisonment, not the aggregation of multiple offenses. Finally, the defendant makes various contentions regarding the handling of his probation matter. As the trial court correctly found, these issues related to trial stage issues and not the sentencing proceedings. As such, they were not within the jurisdiction of the trial court in correcting an illegal sentence. Therefore, the trial court should have dismissed rather than denied these aspects of the defendant's claims. Unless the court has any questions on these issues, the state would rely on its brief for the remainder of its arguments and respectfully request that this court affirm the judgment in part and order a dismissal as to those aspects of the defendant's motion over which the court lacked jurisdiction.
And I see no questions from the panel, so thank you for the argument. Mr. Marshall, you still have 5 minutes for rebuttal.
Yes, thank you, Your Honor. The state seems to be arguing that because I was charged with a criminal, I was charged with criminal offenses in 2007 that the enhancement under that, under another statute in which there's a two-part information which is required, which was written for a reason, is because over the statutory maximum that was enacted by the legislators on the sentencing scheme for burglary first is only 20 years. But in order for them to sentence me over the statutory maximum, there have to be another part, which is the second part information, in which a jury is required, or you can waive, in which I did. I only waived my right to a jury trial and to have the prior convictions. But I never admitted the fact that he could have given me, if the judge would have told me that, and I can also give you 60 years when extended incarceration based on that, from what my attorney told me, I would have made the court prove their process. And in Article 1, Section 8, it says, in all criminal prosecutions, the accused shall have a right to be heard by himself and by counsel. And it says, no person shall be held to answer for any crime punishable by death or life imprisonment unless on presentment of an indictment or grand jury, except the armed forces. And it also says, when it speaks in the Connecticut General Statutes, when it speaks about life sentences, it says anyone who's facing the possibility of life sentences. And there was two cases I had that that it's in my brief, but it was two cases in which it was a guy, he was charged with first-degree burglary and another charge, and then they charged him with an enhancement. And with the enhancement, the judge felt that because he didn't have a probable cause hearing, I think it was in Bajorklin in another case, but because he didn't have a probable cause hearing, he dismissed the enhancement because it was the possibility that it could have gave him a life sentence. And it's in my brief. It's in my brief. But there's no language that also says that an aggregate sentence of a life sentence, because, Your Honor, if that was the case, then the state will easily be able to bypass the probable cause hearing and form its sentences in the aggregate to give a person a sentence which forms a life sentence. And that right there will be unconstitutional. So the states are very, very, very good at what they do. The states are very good. I mean, the prosecutors are very good at what they do when they form sentences. So if there's anything in which he knows that a probable cause hearing would not benefit him, he can take any sentences and put them together to form a life sentence, and then say because aggregate sentences within that scheme, wasn't written in the Constitution. But it also wasn't written in there the way the state puts it, as aggregate sentence being, not qualifying for a life sentence when a probable cause is required. So the argument can go both ways. The state did not present any evidence that proved otherwise. The judge even says that Judge Pisano, in his memorandum of decision, even said that because there was no language or he couldn't find no case to support it, he just made a decision on it. And now the state seems to be doing the same thing. She's saying the aggregate sentences, thank you, the aggregate sentences that makes up a life sentence doesn't qualify for a probable cause hearing because it's in the aggregate. Any court, any prosecutor can put sentences together to make up a life sentence and bypass probable cause, which would not be fair to anyone. And again, I asked that the court defer to my brief because it's more articulated in my brief.
Okay.
I'm finished. Thanks.
All right. Thank you very much. Thank you both for working with us today in this virtual courtroom. We will take the matter under advisement and we will stand in recess until 10:30 this morning. Have a good day.
Okay, thank you.
Thank you.
Thank you.
Bye.